People versus Erik Menendez. He is in court with his attorneys. People are represented by Mr. Kuriyama, and we're ready to proceed with a hearing in regards to matters relating to the testimony of the next witness. I'm sorry for the delay, but there was a mechanical breakdown that prevented me from getting here earlier, but we're now ready to proceed. I did receive the materials that council had submitted to me, some of it this morning and some this afternoon. Can I have a little more information from the parties as to what exactly it is that you want to address in this hearing?
Okay, Aaron, I think on June 17th, the court indicated, which was the time that we were doing evidentiary discussions about evidentiary hearings, the court wanted to make inquiry of the witness Cignarelli concerning, let me just summarize what I think the court decided. One of the issues before the court on that day was the admissibility of the screenplay evidence. The court ruled at that time that the second screenplay is not relevant and would not be used in any way, and made a tentative determination that the first 2 pages or so of the jointly authored screenplay might be admissible, but that you wanted to hear from the witness more concerning the genesis of that material. The second thing.
Yes, is that something that you want to proceed with today?
Yes, sir.
All right, and Mr. Kuriyama, did you wish to be heard? You apparently had a misunderstanding or different understanding in your opening statement.
I did.
At page 3311 of the transcript of June 17th, I indicated that we would hear further from Mr. Cignarelli as to the nature of authorship of that particular screenplay or script.
That's correct. I've had a chance to review that transcript.
All right. And what else is it that the parties wish to discuss today?
The other thing that the court reserved ruling on until it heard from Mr. Cignarelli was any other evidence of spending or financial gain that somehow involves his knowledge that the people wish to admit against Erik Menendez.
Well, I didn't defer ruling on that. I don't think it was presented to me as to what exactly it was that there was an objection to by the defense, or what it was the prosecution was offering.
There was a bit of tug of war because in the early police statement, which ultimately Mr. Cignarelli corrected, there was some intimation that there had been a statement made by my client. Now, he has indicated in his most recent interview, which I've also submitted to the court, that statement was not made by my client. But nevertheless, his grand jury testimony and some of the things he is saying in the latest statement, I believe the people wish to introduce, and we don't believe that those things are probative on the issue of motive. So I thought we should have the court hear what he has to say on that issue in order to decide whether or not it is probative on pre-crime motive.
Well, does this relate to evidence of financial gain or other matters?
Yeah, financial gain.
And
has to do with spending, and
all right, is there a dispute that, let me
spending and talk about spending,
okay.
Let's put it this way.
All right, let me ask you this. Is there a dispute as to whether your client actually did this spending, or is it a dispute as to whether he told Cignarelli of it, or whether Cignarelli has firsthand knowledge of it? What is the dispute?
Well, there's a dispute as to whether or not the kind of so-called spending evidence that Mr. Cignarelli would be the witness for is at all relevant on the issue of this killing for financial gain.
Okay.
The court was going to review the specifics. The people did submit a pleading indicating the specific aspects of spending that they were going to seek to use against Erik Menendez, and some of that comes from Mr. Cignarelli and is in very vague form.
All right.
Well, in the form from the defendant himself in the interview or a conversation that took place on November 29th, 1989.
All right.
It's a conversation with Mr. Cignarelli.
All right. Well, we're talking about different things here. One is whether the evidence is generally admissible against the defendant, and The other aspect is whether or not the people have evidence that they can introduce as legally admissible evidence, aside from whether it's relevant as to whether Cignarelli has any firsthand knowledge of these events.
Right.
I did receive the prosecution's offer regarding spending evidence relating to Erik Menendez. Some of that relates to things that defense counsel wanted to litigate in regards to the purchase of a condominium at Marina City Club, and you got a witness here yesterday that we didn't get to.
That doesn't have anything to do with this witness. What
Well,
has to do with this witness is under number 11, number 13.
you're talking about the prosecution's offer?
Yes, Your Honor, the prosecution's offer, they have a series of numbered items, and number 11 is, it comes up supposedly in this conversation with Mr. Cignarelli on November 29th, 1989. 13 is idle talk during that same conversation.
All right. Well, let's clarify some matters here from the court's perspective. I don't intend to have a preview of Cignarelli's testimony and a dry run of his testimony and have him testify to all things and then discuss them and edit them. You have numerous transcripts of his interviews with the police and numerous police reports, and we can use those as a basis for this litigation. I don't intend to take testimony unless it relates to a matter that has not been clearly established in these prior interviews, and it would have to be a very limited issue that we would deal with by taking up testimony.
I agree, Your Honor. I think that just to stick with this issue for the moment, that the only thing that would be worth taking testimony on is the thing that's been ambiguous from before, that the statement that he reportedly made in his November 17th statement that he then apparently corrected out of that statement subsequently, so that in his final interview on June 22nd, he basically says, Erik never told me that, that's just my assumption.
Okay, the issue is whether or not at some early interview with Craig Cignarelli, Cignarelli told the authorities that Erik Menendez told him when he admitted his involvement in the killings of his parents, that he had done so or was motivated for the money. And is this something the prosecution intends to offer by way of Cignarelli's testimony?
Yes, in particular, Your Honor, the dispute here is whether Erik Menendez said specifically, we did it for the money. Mr. Cignarelli has informed us that he didn't specifically say that, but he said other things which led Mr. Cignarelli to believe he did it for the money. And there will be testimony about that.
And that's the testimony I think we have to hear before the court can conclude that it's anything but Mr. Cignarelli's speculation or opinion.
Well, I don't have to hear it at all. We could hear what it was that Cignarelli says that Erik Menendez told him that caused him to form that opinion without ever hearing his opinion.
Okay.
And I don't see any reason to have a hearing at this time on those subjects. Cignarelli can testify to what he says your client told him.
Well, Your Honor, it's just so unclear in the police report. He's never asked, you don't know what the questions are that lead to the conclusions in the police report. There's just, we've never been able to get a handle on it. And in fact, for example, before the grand jury, Mr. Kuriyama asked, again, trying to pursue motive, he asks Mr. Cignarelli, did Erik ever tell you why he killed his parents? Cignarelli says no. Then Mr. Kuriyama pulls out, well, did he ever tell you all great leaders have no parents? Yes. Well, that's totally out of context. I would like to hear for the first time, in what context was that said, if they're going to offer it? And what relevance does it have to this issue? Because in the same corrected police report where that first appears, apparently Mr. Cignarelli has written notes in the margin that that conversation was completely separate and apart from the conversation in which Erik reportedly told him that he killed his parents. And we just never heard this linkage. And it is foundational to whether, it isn't just something that can be heard by the jury. I think it's a foundational source of personal knowledge before we can talk about it in front of the jury.
Again, the court does not intend to take a deposition of Cignarelli. This is material that has been gone over, and it's been discussed in numerous prior interviews. Yes, I agree with you that you did not have an opportunity to cross-examine Cignarelli on that subject, but you will.
But no one had an opportunity to openly examine him on the subject. He was simply led in front of the grand jury. We don't really know what he said.
That's the nature of the beast. That's the way the grand jury proceedings take place. The way this trial takes place is the witness gets in front of the jury, tells what the witness has to say, and the defense gets to cross-examine them.
All right, well, we're certainly taking the position that Mr. Cignarelli may not offer his opinion as to why this occurred.
Well, I didn't hear that the prosecution was offering that.
You're not our
As I indicated, what Mr. Cignarelli may be asked is those things that were told to him by Erik Menendez, and his ultimate personal opinions would not be relevant and would not be admissible.
What they're trying to do, Your Honor, is use Erik's statements about making money in the future as part of their financial gain motive evidence. And our objection is to Mr. Cignarelli saying, Erik and I had, lunch or dinner at this restaurant on November 29th. And he was talking about how his uncle had told him if he invested certain money with his uncle, he'd make money down the road. Now, we object to that. That does not seem to be financial gain evidence.
Okay, well, we had a discussion of the issue of financial gain in a general sense. And the court ruled that evidence of financial gain is admissible evidence in this case. And it is admissible not only to the extent that it relates to the state of mind of the defendant prior to the commission of the crime, but also those things that he said shortly after the commission of the crime that are in conflict with the statement made to L. Jerome Oziel, as you refer to him, relating to the fact that he did not commit the crime for the money. He did it for some other reasons. So, as I said before, the defendant would like to benefit from that statement that is attributed to him by Oziel that he did not do it for the money, yet would object to other evidence that occurred at or near the same time as those statements that are in conflict with that, in that he was spending money and contemplating spending large sums of money that were in a much different form and nature than existed prior to the killing of his parents.
Well, what is close in time, Your Honor? Now the ruling keeps getting broader and broader. First, we talked about something that was done 4 days later, and that was the basis on which the court said that the purchase by his brother of Rolex watches, one of which he wound up with, was proof that he killed his parents for money. Now we're talking about months later, two young guys BSing over a meal, each bragging to the other about what they're doing or thinking of doing someday in the future. Now, the real issue is at what point does relevancy draw a line that what he's saying to his former buddy about grandiose plans that his family has for him is still evidence that what he did months before was for financial gain. And so we're just asking the court to draw some lines here.
Yeah, that's the issue without the editorializing that you've added to it here, your interpretation of it. Well, you have your own interpretation of it as far as what was said and why it was said. But that is the issue, and that is what we are going to discuss. The court did not rule that the only evidence admissible in relationship to Erik Menendez was the purchase of the Rolex watches.
That was the only spending evidence.
That was the only one that was offered at that time, and the court deferred further ruling until the prosecution submitted to the court a list of those things that the prosecution intended to do. And earlier this week, the prosecution finally did submit that list. So that's why we're here now.
Yeah, so that has, first focusing on Mr. Cignarelli, I think clarified the issues that we need his testimony on. There are other issues that I indicated to the court in the police reports that we would be objecting to for a variety of reasons that don't require testimony from him.
Right, well, as of now, the only thing that I can see Cignarelli testifying about has to do with the screenplay. I haven't heard anything else that relates to matters that require his testimony.
No, just for clarification, in the statement given by Dr. Ozio, he recounted how Erik had told him that his father had nearly disinherited him, and that was further evidence of the need to get rid of his father. Now, Mrs. Abramson states that it was the brother Lyle who bought the Rolex watches and the money clips, but in fact, Erik Menendez was with him 4 days after the killings, and he purchased the Rolex watches.
Yeah, we went through all that in the hearing on June the 17th. As the hearing unfolded, the defense conceded that the defendant was not only present at that time, but also the defense conceded that ultimately the defendant, Erik Menendez, obtained one of those watches and so admitted to Detective Zoller in the November interview in New Jersey. So that's basically where we were in June, on June 17th, and now the prosecution has submitted additional things that the prosecution wishes to introduce not things, but additional pieces of evidence relating to spending that the prosecution wishes to introduce to establish the defendant's state of mind in time, close proximity to that in which the shooting deaths of the parents occurred. And the prosecution list of these things are right here. You indicated the two that you had objected to were...
I object to a number of them if you want me to just.
Oh, I thought you said 11 and 13 were the two you objected to.
Well, that has to do with Mr. Cignarelli. I object to a number of them. If you want me to indicate my objections, I can do that, and I can indicate which ones I don't do.
All right.
Okay. Well, you know we're gonna be litigating number 2, which is the Bel Air Hotel.
All right, and that is one that you want to do today, or you need some
No.
witnesses, or?
No, we were gonna do that next week. I didn't order witnesses after today.
All right.
3 you've already ruled on. 4 we're not objecting to, because you've ruled that receiving the insurance money is admissible against both, so there's no point in objecting to 4. 5 we don't object to for the same reason. 6 we don't object to for the same reason. I should say, however, Your Honor, just as a point of order, that with respect to 4, I have never seen such a document, a death claim filed by Erik and Lyle Menendez.
All right, it hasn't been submitted to me either. The attachment doesn't seem to.
Doesn't contain it. 7. 7 we will object to, and we will provide testimony concerning that.
Are you prepared to do that today?
No, Your Honor, that's the same witness says. This is the lawyer who was advising him and doing all this.
What on the, this will relate to hiring of the tennis coach at $60,000 a year?
Well, actually, it wasn't 60,000, but whatever it is, yes, it's the
It's
same person.
$5,000 per month.
Yeah, but it wasn't. We'll do that. Same person, same issue. The same is true for 8, which is the non-purchase, as I call it, since it was never purchased, of a condominium at the Marina City Club.
All right, that relates also to Lyle Menendez. So
does the Bel Air one.
well, the Bel Air Hotel, the renting of the suite for $1,300 per day is something that the prosecution wants to introduce as to both defendants, as well as the purchase of or attempt to purchase a condominium at the Marina City Club for $990,000. And the paperwork that's been submitted here, although the prosecution says it relates to Erik Menendez, the paperwork seems to show Lyle Menendez.
Yeah, the witnesses will testify that they came in together to make the purchase of this almost $1 million penthouse suite, and that Erik Menendez put a deposit of $29,700 on. Well, the check is dated September 15th, 1989.
September 15th?
Yes, I think he missed it because I think the paperwork indicates it was October 15th.
Yeah.
But in Eric's handwriting, his check is dated September 15th.
Anyway, we're gonna produce testimony concerning that so that the court can weigh its probative value against its probative value. 9 we would object to because the court had said during the June 17th hearing that You know, it would have to be something that has some significant relevance. And an 18-year-old kid buying a Jeep, again, with the advice and negotiation of his lawyer, we don't think is sufficiently probative. So 9 we're going to be objecting to. We will have to be putting on testimony about that as well.
All right, and it all relates to the same lawyer's testimony?
Yes.
Okay.
10 we don't feel is sufficiently probative. He leased an apartment in November and he had a roommate. If you want us to put on testimony to prove he had a roommate, we can do that.
Your Honor, this was the little apartment.
Finish and please.
Yeah, save all your ammunition there.
Yeah, same one. It's a 3-bedroom apartment in condominium. It is not a penthouse, it's just an apartment. His brother leased an apartment next door, my understanding. But in any event, I don't know if this is the time to rule on that, but I want the court to know.
To drool on that?
No, I mean, whether the court today is going to rule on whether, you do rule on these things once in a while.
Yes. And then you drool when I rule. So. Nothing. You missed it. Let's go on. Let's go on.
I miss, well, good. That shows I'm not perfect. Anyway, so we're going to object to that as well. Well, you already knew that. You were keeping it a secret. We're objecting to that as not sufficiently probative, especially given how late in the game it is. The same with the pool table. And the same with the unpriced vacation in Cancun, I suppose. I'm not gonna argue this now, but we are objecting to that, especially since the people can't prove spending. I suppose he's not allowed to take vacations or cruise and kill his parents for money. And then the skiing vacations, also nothing more than talk between himself and Mr. Cignarelli in the restaurant. The real estate purchases that he never made, where he was supposed to be going into some kind of thing with his uncle. And buying a special order Rolex, which he never special ordered, and we don't know what they're talking about. Those, which seem to be Mr. Cignarelli's idea anyway. Those are the 3 pieces from Mr. Cignarelli's.
All right, and let's go over to the perfect Mr. Kuriyama, and you can tell us your position.
Your Honor, this is the number 9, with respect to the Jeep. It's the cheapest Jeep, according to Mrs.
Wrangler,
Abrams.
not a chair.
It was a $21,000 Jeep that he purchased about 2 months after the killing. It's just one of many purchases made by Erik Menendez.
Okay, well, let me say this, and you can continue. The court requested the itemized list of things that each defendant is alleged to have done, or things that he is alleged to have spent money on, so that the court can exercise its discretion and analyze the expenditures to make a determination as to what is relevant evidence, what is probative evidence, and to balance it against any prejudicial effect. And you've listed them here, and basically what Ms. Abramson has done is argue her position that it is not probative and it's prejudicial. And your position is that some or all of these things are relevant and non-prejudicial. So do you take the position that all of these things are going to be offered by the prosecution and are admissible, or that you have listed all of these and some of these you would not be offering?
I have listed these and I had intended to offer them all.
Okay. All right, go ahead. You were talking about the motor vehicle. The defense is going to offer some evidence, apparently, that no matter what it was Erik Menendez bought, it was done by or under the counsel of an attorney, and therefore somehow it doesn't relate to personal decisions that he made.
Well, it's not a spree, which I think is how it's been characterized. It's not reckless. It doesn't show someone who couldn't wait to grab the money and start throwing it around.
Well, the issue to some extent is, was there a change in lifestyle and spending patterns from what existed before to what happened after the killing of the parents?
Well, those are 2 different issues, Your Honor. A change in lifestyle, that's easy. There was no change in lifestyle. They always lived very, very well. Was there a difference in spending pattern? Well, the people who spent for him were his parents. Now he is spending at the same rate and the same kinds of things that were previously provided.
Well, did he have a motor vehicle
Yes.
before August the 21st? And,
He had a Ford F-150.
Two.
okay, and he ended up with a different motor vehicle after the killings.
Yes, but he didn't buy a Mercedes. I mean, he bought an equal value type motor vehicle.
Well, but he bought another vehicle, and I don't know if it's an equal value. Those are the types of things that would have to be discussed further, and I hear argument from either side on that subject.
Okay, well, we're not gonna argue that now because we need to hear the evidence.
Yeah, you have your witness you want to bring in to deal with the issue of relevance, whether it really is relevant evidence, and that has to do with the testimony of this attorney.
Right.
Okay. All right. Did you want to carry on further at this point, Mr. Kuriyama, with your offer of proof, or do you want to wait until we hear from the defense witness on the subject of why these expenditures were made?
With respect to the attorney that they intend to.
Well, you can't anticipate exactly what it is he's going to say, but do you want to just discuss further the admissibility and relevance of this evidence, or do you want to defer until we hear the defense evidence?
Well, we have to argue it sometime later. Anyway.
Okay, so we can defer. I really hadn't anticipated that we'd be going through all of this since the defense had indicated they have witnesses they want to have testify both on the Bel Air Hotel spending and the purchase of the condominium and some other items here.
I should note, though, Your Honor, on September 17th, 1989, in an interview with Beverly Hills, the detectives in the case, Erik Menendez indicated that he got an allowance of $150 a month. I think this is a shaft of change from that statement.
Okay, well, that's all argument that we should, you should marshal it all and get it all together in a cogent form and present it to me. All right, again, other than Cignarelli's testimony relating to the first two pages of the screenplay, the first screenplay, what else is there that requires his testimony?
I don't know now that there is, if you want to make the decisions on I noted, marked up the report so that the court could determine what of the other things that are contained therein are admissible in front of the jury. And one of the things has to do with the Calabasas burglaries, for example. That keeps coming up in these.
Well, let me ask the prosecution, do you intend to introduce evidence relating to the burglary arrests and prosecution of Erik Menendez or the involvement of Lyle Menendez in burglaries that occurred prior to this crime?
Yes, Your Honor. I think it was admissible under Evidence Code Section 1101B as motive evidence as reflected in Dr. O'Seal's statement concerning the October 31st, November 2nd, 1989 sessions with the brothers. In particular, the brothers indicated that their father taunted them during the Calabasas robbery, which was actually a residential burglary, by making fun of Erik and Lyle and telling them how stupid they were for doing it in ways that left the police all sorts of clues as to how it had been done. In reality, Lyle and Erik both nodded to themselves that they thought they did so perfectly that had the father not set them up to be turned in, that they never would have been caught. And each of them independently began thinking about how unfortunate it was for them to commit perfect crimes and that they had a belief that they could commit further crimes and never be caught.
What are you reading from?
I'm reading from the transcript provided by defense counsel of Dr. O'Seal's notes.
Yes.
Slender thread upon which to prove up other crimes is our position on that.
Wait. You mean that there's no evidence of these other crimes that the prosecution has, or that there's
That's not what I mean.
There's no basis for its admissibility?
Yes, that's what, and they're saying that they are now entitled to prove the facts and circumstances of these burglaries. They have on their witness list the victims, for example, and the investigating officer, on the theory that because they had a discussion with O'Seal that their father taunted them about being so stupid that they got caught, that bootstraps into being a motive for killing him because he taunted them. They weren't as good a crook, I suppose, as he considered himself. And secondly, that then allows them to prove up all the facts and circumstances of those burglaries. You know, I think that's the sort of, that I think is a pretty simple thread.
Well-
For the juvenile crime, which resulted in 654 probation and dismissal, is now provable in this murder case, and when it's clearly crime propensity by the evidence.
Well, it goes beyond that. I'm not going to speak for the prosecution, but I'll hear the prosecution's offer of relevance. And quite frankly, the prosecution has never presented me anything in writing that I can recall that relates to their intent to offer this as evidence in this case. This is the first time you've mentioned it, Mr. Kuriyama, that you intended to offer it. And is this something that is going to be offered in regards to both defendants?
I intend to offer it against Erik Menendez.
Does the district attorney intend to offer it as to Lyle Menendez?
No, Your Honor. Might I just add that Erik Menendez told one of the investigating officers in the Calabasas burglaries that he, at the time of one of the two burglaries, July the 14th of 1988, he was at the movies with a friend of his. And one of the reasons we feel it's relevant as to Erik Menendez is that he used the same alibi in one of those burglaries as he used in the crime at issue. And in the case of People versus Wilson, which is at 227 Calat 3rd, I believe it's page 1212, the court admitted evidence of a prior burglary and found that evidence was relevant under 1101B, not only because of the similarity in the type of crime, but because the defendant used the same excuse in the prior burglary as he had in the burglary at issue.
Okay, well, the crimes are obviously not similar in any way.
Well, not only that,
Wait. But
Yes,
again, you're not offering this against Lyle Menendez. You're
No.
only going to offer it against Erik Menendez,
yes, Your Honor, and the reason.
even though there was evidence that Lyle Menendez committed a burglary as well.
Yes, Your Honor, and that's because we have two juries and it's for tactical reasons. But my feeling is one of the main pieces of probative value of this. First of all, Erik Menendez did in fact confess to the burglaries to Deputy John Loftus, who's on the witness list. Lyle Menendez did not. Secondly, the fact that he offered the same alibi at both the burglary and for the murders, I think is extremely probative as to this defendant. Lyle Menendez did not offer that alibi.
All right, again, this really is the first time the prosecution has ever announced that that was your intent to offer evidence relating to the burglaries. The only other time it came up was when the defense filed a brief the day of opening statements in the trial objecting to reference to this material, and the prosecution indicated it would not refer to it in its opening statements.
That's correct, Your Honor.
Wait. Yeah.
I had given counsel notice that I intended to put on the burglaries. They responded with their objection, and I thought we would just simply argue it.
It's normally, a type of thing that is of such a nature that it does normally warrant a little bit of briefing. It does relate to substantial issues in the matter. And I would say this, the defense in its opening statements has, both as to this defendant and as to the co-defendant, has raised the specter of the entire relationship of parent and child going back to day one until the final day, and has raised the issue of why the parents treated the defendants a certain way and what motivated the parents to have a certain attitude towards the defendants. And also, there is some issue here as to why the defendant, or both of them, were going to Dr. Oziel. And it's my understanding, perhaps I'm wrong, that one of the reasons they were going to Oziel was as a result of the juvenile court proceedings relating to the burglaries, number one. Number two, the burglaries and the parents' reaction to the burglaries, whether it was the reaction of an understanding parent or an intolerant parent or whatever it was, could very well be relevant and pertinent evidence in this case. And it seems to me the defense would have a difficult time arguing that all the bad deeds of the parents should come before the jury. Yet this particular incident that relates to the relationship of parent to child should not be part of the overall picture that the jury hears to decide this case.
Well, Your Honor, our position would be, if you'd like to hear what it is, but I can't speak for Lauman in this jury, our position would be this, that to the extent the burglaries are relevant at all, they are relevant to that relationship. And that in other words, we're not objecting, we won't be, unless it leads to opening up the entire burglaries and all the details and what was stolen and what was it worth and how did that all work out. That we do object to because we don't think that's relevant and that has the prejudice outweighs the probative value. But we tend to agree with the court that to the extent the parents had certain reactions to those burglaries, and to the extent that was discussed with Dr. Oziel, and to the extent Dr. Oziel's telling the truth about it, that might well be relevant.
Well, the way the burglaries were committed and what the defendants told the parents about the burglaries and how they were committed and all of that could very well relate to how the parents reacted to it.
Well, of course,
I don't know. I don't know what the evidence is and how it would be presented, but I'm just throwing that out as part of the mix here when the defense took the initial position here that you would object to any reference to the burglaries, and now you're backing away from that.
no, I didn't take that position. I just wanted to have a discussion about the burglary evidence. They didn't put the burglary victims' names on the witness list until last week. That's why it all came out the way it did. That's why it was just before opening statement that we asked the court for a ruling. And we don't think it's appropriate for them to prove up the facts and circumstances of those burglaries. And we think it gets into collateral issues. They don't know. They, being the prosecution, do not have any evidence of how the parents in fact reacted, apart from what Oziel says in the statement that they have.
Your Honor, I do have.
If-
You're not finished.
No, nothing. And so, our position with respect to Erik Menendez is in some limited fashion, perhaps the burglaries are relevant, but not in the sense of trying those cases again in front of our jury. Mrs. Bozanich's statement does not make a great deal of sense to me. If Erik Menendez confessed, and he did, volunteered, confessed, they turned back all the property, full restitution was made to the sheriff's department about these burglaries. I don't know what she is talking about with respect to an alibi. He never gave an alibi, he gave a confession.
Your Honor,
And that was the basis of the juvenile court filing.
All right, well, again, we've been throwing this material out, but it does warrant briefing and a specific offer of proof by the prosecution exactly what it is you intend to put on here so that we don't waste a lot of time. It might be that there won't be much of a dispute between the parties as far as what it is you
The
intend to
immediate
offer. I don't know.
problem, let me just point out the immediate problem now. The immediate problem is Mr. Cignarelli has this information, and he is supposed to testify on Monday.
Well, he can always come back and testify later on other matters if we don't have resolution of this. And maybe we will, I don't know. But you can't just make a haphazard offer of proof here and cite a case to the court without giving the opposition a chance to research the subject and both sides present the court a thorough briefing on the subject. If there is going to be a dispute regarding the specifics of what the evidence will be. And perhaps you can just discuss that among yourselves, decide what it is that you're ultimately going to offer here as to whether there will be a dispute as to whether that would be admissible or not. I would certainly entertain an offer by the prosecution that goes beyond what the defense is willing to concede and decide what is and what is not admissible. But I think you ought to do more than make an oral presentation here.
I'll have a brief filed on Monday morning. And with respect to the evidence regarding the parents' reaction to the burglaries, number one, we do have a transcript of a conversation that Detective Zoller had with Erik Menendez. And at page 32 of that transcript, Erik Menendez states that he went to see Dr. Oziel because his parents made him get the psychologist after the Calabasas thing, meaning after the Calabasas burglaries.
Your Honor, there is another issue that all this raises, though, and that is the fact that the psychotherapist patient privilege still adheres to that, to going to see Oziel, to those sessions.
No one's disputing that.
In that regard, Your Honor, we are going to be filing a motion Monday pursuant to Evidence Code 1016. which indicates that once a defendant puts his mental state at issue, that other psychiatric records should be made available to the prosecution. Now, it may be premature to do that until the defense is actually put on the evidence, but I wanted to give ample notice to the court and counsel that we would be making that motion.
All right.
And one other thing, Your Honor, with respect to Mrs. Abramson's, Ms. Abramson's statement that Erik Menendez volunteered and confessed to the burglaries is not true. At first, he said that he was at a movie with Andy Pierce on the night of one supposed burglary, and it wasn't until many days had passed and the investigation had focused on him that his father made him turn himself in to the Malibu Sheriff.
All right, well, that all relates to the nature of the offer of proof and what it is that you intend to introduce and what is the defense position as to admissible evidence. And I have no firsthand knowledge of this at all, or even third-hand knowledge. This is all pretty much new to me based upon what you're telling me right now. So other than what little bits and pieces I picked up from the various interviews of Cignarelli and the defendants, I have no other information about this. All right. Getting back then to what else, if anything, we would have Mr. Cignarelli testify about, other than brief testimony relating to the first screenplay. Do counsel have any specifics?
Well,
And further, we can, before getting to that, if you want to discuss specific objections to significant evidence that the prosecution will seek to elicit from Mr. Cignarelli, we can do that. Doesn't require his testimony. As I said, he's been interviewed many times. Quite a bit of the material here that you've underlined or highlighted doesn't seem to me to be necessary for the court to discuss. However, we got off sidetracked with this when we start off with the prosecution indicating they intended to offer evidence of the burglaries.
Right.
Right. So going beyond that, what is your next major objection here?
Yeah, can I suggest we just do the witnessing and we can get on with this? I don't really like discussing his testimony in front of him.
Well, we're not, is he here in the courtroom?
It was.
I don't know if he is or not. Again, he's not testifying today on these matters, so what else
Yeah,
is
I
it?
know. Well, I had highlighted it for the court.
Well, again, what is it that the prosecution is offering? I don't,
Sorry.
things are highlighted, things are crossed out, I don't know. We have some things with green.
The things that are crossed out are other witnesses on the same page, Ron. That's just how you ignore this.
Oh.
The things that I have yellow lines through are the things I'm objecting to. The people have not told me that they're offering anything less than the entire content of these police.
As I understood it, the prosecution was going to review those matters and decide what it is that they were going to offer and what it is they weren't going to offer, and let me know about it before I took the bench so that we wouldn't spend a lot of time discussing those things that they're not going to offer.
Well, they
Yes,
tell me.
with respect to the burglary information.
Okay, you said you're going to offer that. So
Yes.
are there other matters here that the defense has indicated objection to that you don't intend to offer?
Yes. there's-
Okay, then what you can do is discuss that with the defense so that we don't have to spend any time on that.
Yeah, the
And,
perfect crime stuff.
well, I'm not going to hear that at this point. I want to hear after the prosecution has discussed it with you, so we don't spend a lot of time talking about those things that are not going to be offered. All right, so we'll take a short break and we'll have you do what I thought you had already done, talk about those things that you won't be offering so that we can narrow the issues here about those matters that the defense is objecting to that you are going to offer. All right, we'll take a short recess and let you confer. All right, let's resume. Everyone is present? Yes.
What do you want, what do you want us to tell you at this point, Your Honor? We've talked.
Yes.
What would you like to know?
Well, I would like to know that you have narrowed the issues.
We have narrowed the issues. Would you like to know the remaining issues?
Well, you have objections to the introduction of certain things that the prosecution intends to introduce.
Yes.
Okay. And what are they?
Okay, if the court would turn to the first report of Cignarelli that I submitted. It says on At the bottom, it says page 3 of 10.
All right.
Okay, at the last sentence of the first paragraph, which begins with the words, "He did say that the two were very mysterious," etc. Can you see that?
Where is it now?
Mike?
No, just tell me where it is
Okay,
again.
it should be in the first full paragraph, which begins at approximately 2200 hours. IOs interviewed Craig Cignarelli, witness 15.
All right.
Okay, the last sentence of that.
Okay, yeah. All right, I see it.
We're objecting to that.
Okay. And you're offering that?
Yes, Your Honor.
Okay.
I believe it's relevant that it goes to their habit and their interest in surprising people and sneaking up on people. It goes to the lying in wait special circumstance, as well as the crimes and photographs. And it comports with Dr. Oziel's statement that the brothers told him that they surprised their parents. I think it is relevant evidence.
Well, assuming it's relevant, is it not just a conclusion here? Is there some specific instances that Cignarelli has in mind?
I believe so.
I haven't heard about them if he does.
Well, as it's presented here, it's just a conclusionary statement, and as such would not be admissible. It would have to relate to specific instances.
That I would take would have to be significantly similar to have superlative value on the issues in this case.
Well, we'd have to hear it. I don't think this is the type of thing that requires a hearing outside the presence of the jury. It's not that sort of information, unless it relates to other crimes.
Well, that's what I don't want.
Does it,
I'll have to get a clarification on that. I thought we didn't have some testimony on that day,
Well, as I said, you can talk to the witness. It's your witness. You know what the witness is going to say theoretically before you ask the question. So if it relates to another crime, then obviously the matter should be heard outside the presence of the jury. If it's just some innocuous thing of sneaking up on the parents to play a practical joke or something, I have no way of knowing. If that's all it is, then obviously it's not something that requires a separate hearing.
But he still needs personal knowledge, whatever it is.
I would, yes.
Okay. The second thing is, we've already talked about the evidence, information on that same page concerning burglaries. Turning to, which the court's reserving, turning to the next page of that same report, page 4 of 10, the top part has to do with the screenplay evidence, and that's pending the hearing for the court's final determination on that. The next objection is in the next paragraph, in which reads, he also said that he and Eric often sat around dreaming of committing the perfect crime, etc., etc. We object to that. And particularly when you read the next paragraph where the investigating officers asked them what they thought the perfect murder was, and it's neither the murder of the screenplay nor the murder of real life here, so.
We agreed to take out the second full paragraph.
The one that starts IOs,
Yes.
Yes,
all right.
but the problem is that makes it even worse, because then it leaves for someone to speculate that the perfect crime is the crime committed here, and there's no such indication. So we think there's even case authority about introducing evidence where the defendant talked about committing perfect crimes unless he's talking about this particular crime. And this is just, according to Mr. Cignarelli's handwritten notebook, in fact, the way this discussion really went is they sat around and talked about the perfect date, the perfect dream, the perfect vacation, the perfect robbery, and the perfect murder.
And what is it that you're offering this for, Mr. District Attorney?
The conversations that the defendant and the witness had regarding perfect murders.
And the defense says that there is a specific case that deals with this subject, is that right?
I haven't seen it.
I don't have it with me, but does the court need a citation, or is it admissible now in a murder trial that a witness says that he and a defendant sat around and talked about perfect crime?
Well, you said you had a case that's right on point,
I
so.
believe there is a case that deals with talking about perfect crimes. I believe we briefed it, did we not, this morning? We made reference that we would. If we need a citation, we'll give the court a
Well,
citation.
you're telling me there is a case that deals with this subject, so I'd like to see it.
Well, we'll cite it to you, we'll go back and
All right.
get it. But I shouldn't even think it would take a case like that.
Well,
Yeah, I think,
I think otherwise you should present that case to me.
I think the relevance is heightened by the,
Excuse me, Your Honor, but there are some rather juvenile spectators in the court who have been giggling through many of the proceedings. I'd ask the court to admonish them to behave themselves.
Okay, go on. I'm sure they will. Go ahead.
I think
Mr.
that the relevance
Kuriyama.
is heightened with respect to Erik Menendez's discussions about the perfect crimes. When Dr. Ozito states that they thought that they had committed perfect murders in this case, I think it's highly relevant in this case.
We distinguish between any statements that Dr. Oziel may testify to about this being a perfect crime versus speculations about perfect crimes, which is only admissible as propensity to commit crime evidence, which is clearly inadmissible.
Well, it also, I suppose, relates to the relationship or his evidence regarding the relationship of Erik Menendez and Craig Cignarelli. This is what they sat around doing.
Well, nevertheless, it's Craig Cignarelli's not on trial for murder. It can't prejudice him.
Craig Cignarelli's parents are still alive.
All right, the issue again would
Barely.
relate to the relationship of the individuals. All
Well, I
right, go
don't,
ahead.
did the court find that, we're not disputing that there was a close relationship.
Well, what they sat around talking about. They didn't talk about dates. They talked about committing the perfect murder.
They did talk about dates also.
But they also talked about committing the perfect murder.
So how is that relevant?
Well, you have the case that you say would relate to this issue, so let's see it. All right. Go ahead, Mr. Kuriyama.
Your Honor, the X'd out, highlighted X'd out portions are not relevant. So we go down to the last two lines of the report dated 11/28/89. The third page. It's the second to the last line where I'm starting Erik.
The last page you're talking about?
The third page among the,
3 of 3, okay.
yes. Actually, it's,
No, Your Honor, he's getting confusing. It's the
No.
11, are you talking about the 11/28 report?
there are a package of reports, Your Honor, that we provided to the court and myself by counsel. It's the third page of that packet.
It's the report of 11/28/89, and
Yes.
it's page 3 of 3. That's what you said, right?
Actually, it's the
Page
third
one
page,
of
it's 1 of 3,
Okay, so it's the first page
yes.
of that report, okay.
The second to the last line, starting off, Erik had told,
All right,
I've agreed that that should not come in, as well as the first line and a half of the next page. Well, actually, the
well, tell me what you are offering and what's in dispute. Don't tell me what you're not offering at this point.
with respect to the other highlighted portion right after the portion I just referred to, I've agreed with counsel that that may become relevant sometime later. This has to do with
The witness
witness
protection program.
protection program, but I will not offer that initially.
All right, again, get to those things that you are offering.
Well, Your Honor, I did want a record of some of these things since there'd be no way if Mr. Kuriyama forgets or what our agreement was to hold him to it, so. I did want to make a record of what I'm objecting to that he's not offering.
We'll do it quickly, otherwise you can do it in writing.
Okay, the
so.
next thing that I know about is in the third full paragraph down on that line. The highlighted part, we did it for the money. He isn't offering that because he agrees Mr. Cignarelli doesn't have that information. The next paragraph, again, is perfect crime discussion. We're again objecting on the same basis.
And I intend to present the perfect crime evidence. With respect to we did it for the money, I will not offer evidence that that's his opinion. I will offer evidence directly from Erik Menendez that would lead to that conclusion. So there is a distinction.
On the next page, Your Honor, there's this second full paragraph. It's a discussion about Erik in Cancun, Mexico.
I've agreed that those should come out.
When we get to the next statement, Your Honor, which I believe is dated 4/3/90 and refers to a March 7th interview. And turning to page 2, the people indicate they will not be seeking to introduce this statement about all great leaders having no parents, and Hitler and Alexander the Great, and the rest of that. But that they will be seeking to introduce, Eric then said that he needed money to succeed in what he wanted to do in life. I assume if they have that evidence, then they could introduce that. He also indicates, Mr. Curiami indicates the bottom of that page, the part that's highlighted, Eric's public posture, he does not intend to introduce that.
That's correct.
Takes care of that statement.
You're not offering the statement, Eric then said that he needed money to succeed in what he wanted to
No.
do?
No, that part I
Yes.
am.
You are
That he
offering
is
that?
offering.
Okay.
What he's not offering is the bottom of the page, that highlighted part about public posture, he's not offering that.
You are offering all great men or
No, I am
No,
not.
not offering great men who have years. Flawed history lesson. Okay, the next statement is, the next report is October 19th, 90. It's a one-page report. The highlighted portion has to do with the witness's fear. I believe Mr. Curiami's position is he won't be offering that unless it somehow becomes relevant.
That's correct, Your Honor.
The next statement is dated August 28th, the next report, August 28th, 92. Same thing, the highlighted portion again has to do with fear of Mr. Curiami won't be offering unless it later becomes relevant.
Correct.
Yes, the next one is the July 6th, 93 statement on page 2, the middle of the large paragraph. If the court's going to introduce, I guess the position there is it again has to do with Mr. Cignarelli claiming that Eric told him that the reason Mr. Menendez threatened to kill Mr. Cignarelli had something to do with the burglaries.
all right.
Now, Your Honor, what I propose to do is there is a transcript of the March 7th, 1990 interview with
Mr. Carroll and Detective Edmonds.
That's correct. And what I'd like to do is quickly go through the parts that Mr. Curiami does intend to offer that we're objecting to, because we have gone through this and eliminated much dispute. The top of, do you have that in front of you?
I do.
The top of page 6, Mr. Cignarelli will not testify to shotguns being used because he does not.
You're going to go through and tell me those things that the prosecution is offering that you
Okay.
do object to,
All right.
not those things that they're offering, they're not going to offer.
Okay. No, I'm gonna leave that. The court's already pretty much ruled that Mr. Cignarelli can testify to, if he has personal knowledge or if.
Okay, let's not put everything that comes to mind on the record here, just those things that the prosecution is offering that you object to.
Okay. I have to just glance and see. Page 12, the discussion about a potential hiding place for guns being a speculative hiding place for burglary proceeds. So they say they are offering that.
You're objecting to that?
Yes.
Do you want a
yes.
ruling now, or is that related
To
to
the
whether the
burglaries.
people offer evidence regarding burglaries?
Okay.
All right, so that'll have to be deferred until the
Actually,
people
you
brief
could
that
do
issue.
It's very speculative in any event, whether they offered evidence on the burglaries or not, that's still very speculative guesswork on his part as to where the guns might be hidden. It's just speculation.
It would sound that way.
Yeah.
This had to do with where they apparently buried some of the booty or the loot that they recovered, that they took from the houses that were burglarized.
Except that this witness doesn't know that.
Well, again, I have no information regarding the burglaries, how they were committed, or what happened to the proceeds. If this is part of your offer of proof, then you'll have to lay it out for me.
To clarify, Erik Menendez showed Fred Cignarelli where apparently he had buried certain items, certain property that he had taken from the burglary site. And there is discussion by Mr. Cignarelli that he suspects that perhaps they buried the guns that were used in the killings of the parents at the same place. So it has to do with both things.
All right, well, the latter part is certainly speculation, isn't it?
Yes.
How could that be admissible?
Well, I suppose that part, their objection may be well taken with respect to the speculation as to that the burial site for the guns being the same as that of the loot that was taken in the burglaries.
And as far as the hiding place for the proceeds of the burglary, that would relate to whether the burglary evidence is admissible or the specifics of it is admissible. And you haven't presented that to me yet.
It's pretty vague though. I mean, what the witness says here is he showed me where the spot was from a road about 300 yards away. He said, it's out there. In another county.
Okay, again, we don't have to talk about that if the people don't end up offering the specifics of the burglary. So there's no sense spending time on that now.
All right, then we get back to the will evidence, Your Honor. Starting on page 17, I think the court had indicated on June 17th that you were talking at that time about the admissibility of the evidence of the computer person that came to the house at Erik's uncle's arrangement. And I think you were questioning the people of how would that be relevant if Erik is only there because he's to meet this person that his relative set up. This discussion that begins on 17 merges both episodes, both the episode, this is hearsay, to Cignarelli from Erik about Lyle having hired somebody to erase the will. In fact, I'm not even sure who Cignarelli's source is on this. That Lyle hired somebody to erase the will, and then that he is there, he claims to be there, Cignarelli, when the computer person that Erik's cousin hired shows up. And that's what this whole discussion is about on 17 and 18 and on to the top of 19.
And what is the people's position?
Your Honor, as the reports indicate, Craig Cignarelli was with Erik Menendez when the man, Mr. Heyman, who was hired by Carlos Menendez, came to the house on September the 1st of 1989. It was at that point in time when Mr. Heyman was in the process of finding the will that a conversation took place between Erik Menendez and Craig Cignarelli, and I intend to offer the statements made by Erik Menendez during that period of time. Now, even though Erik Menendez may not have hired Mr. Heyman, I think the statements made in that context, when Mr. Heyman was accessing the computer, statements made regarding the will are admissible because they're statements by the defendant directly.
Well,
All right, first of all, the people do not dispute the fact that Mr. Heyman was hired by Carlos Menendez, is that right?
That's right.
And that the arrangement was that Erik was just to be there at the request of Carlos Menendez to let Mr. Heyman in the house. And it was Carlos Menendez's idea to have Heyman look at the computer to see what there was in the computer regarding wills. So that you're conceding that Erik Menendez did not hire Mr. Heyman and did not participate in this hiring and just happened to be there at the cousin's request. Is that right? Or uncle's request, whatever. Carlos is a cousin, I guess.
He's a cousin.
That's my understanding.
Okay. All right. With that as a foundation, then when Mr. Heyman arrives, there was a conversation between Erik Menendez and Craig Cignarelli,
Yes.
which is documented here on page 17 that you want to offer.
Yes.
No, it's not really on page 17. See, what's confusing about this, Your Honor, is here's what Cignarelli is saying. Starting his last little speech on 17, he says, Lyle hired someone to erase. There was an old will written that supposedly, and this I got from the police, left everything to the kids. That's what I got from the police. There was a new will written that left some money to the company, some money to other people, and that's what Erik told me. We don't know when. And then this goes over to page 18, where there's this discussion with Erik, we don't know when. From this, we don't know when. And here's Erik talking about Lyle hiring somebody to come in and erase the will. and Eric wanted to know what was on that will, and he's claiming, so he hired someone to come up from San Diego, but this is Cignarelli talking, and yet we know that Carlos Menendez did that hiring, so either Cignarelli's wrong, or Cignarelli's lying.
Or your client told Cignarelli that that's how it happened.
Yeah, which is no doubt the way the prosecution will construe that.
All right. Anything further, Mr. Kuriyama?
No, not on that issue. Your Honor.
All right. What is it that you're trying to prove by this? First of all, can you isolate what it is that was told to Cignarelli by Erik Menendez and separate that from what the police told Cignarelli and what Cignarelli surmised from other sources?
Yes.
And I assume you can do that not just from what's written here on these pages, but from other interviews with Cignarelli.
Correct.
And what is it that you're going to offer?
It's my understanding that during the process of accessing the computer by Mr. Heyman, who was there for a couple of hours, there was conversation by Erik Menendez and Craig Cignarelli, in which Erik Menendez stated to Craig Cignarelli what was on the will, apparently. There was a new will written, and he was interested in finding that will, but knowing apparently that the will had been erased the day before. So the sequence of events is Mr. Whitkin comes, erases the will on the 31st of August. The next day, Carlos Menendez has Mr. Heyman come with a new expert. And this conversation, it's my understanding, takes place on that day, the 1st of September.
Well, this day has significance otherwise in that this was the day that Erik Menendez told Cignarelli about the killing of the parents and that his involvement in it, according to Mr. Cignarelli.
That's right.
And Mr. Cignarelli is able to pinpoint the day as the day the computer person came to the house.
He remembered the computer person in particular because the computer person had his wife when he was pregnant at that time. And that's how he wasn't sure about the exact date. He said it was a day that I spent the weekend with Erik Menendez, and it was a day that the computer guy came to access the will information.
And then Mr. Heyman would testify, or there would be some stipulation, whatever, that the date was September the 1st.
Yes.
Okay.
I believe so. I don't think there's any dispute about the date.
But, there's a great deal of dispute about the date, but that does not that Mr. Heyman was there on September 1st, whether Mr. Cignarelli was. But that doesn't get to the issue of,
Well, if I may, Your Honor, it's been documented that the day that the Heymans were up there at the Menendez house accessing the computer, Mrs. Heyman says that a friend of Eric's was there and she had seen him on television sometime later.
very interesting. But the point is, question is whether people will be able to prove two things. Number one, what Mr. Heyman was doing there. I mean, apart from the fact that a computer person came, that's not a problem, but that he came, that he was accessing the will and all of that stuff, when Eric had nothing to do with getting him there.
Well, if it's documented and Mr. Heyman testifies that it was done at the behest of Carlos Menendez, then it certainly can't hurt Erik
Why is it
Menendez
relevant? If it's
to
done,
document the time that this happened and to establish that Craig Cignarelli was there at that time.
well, that won't establish that he was there at that time. That
Well,
won't establish that Mr. Heyman was there.
No, the people have offered that Mr. Heyman's wife would testify that she identifies Craig Cignarelli as being
She
there.
does not identify Craig Cignarelli at all.
Well, the inference from what Mr. Kuriyama just said to me is that she does.
No, that she saw a friend on television, but Mr. Cignarelli is not the only friend who was on television.
Well, if there's some dispute about that, that certainly can be resolved quickly.
No, it cannot be resolved.
Well, it
It's
seems to
gonna
me
be a
it can.
dispute.
Okay, well, then the people are entitled to put on what they want to put on, and you can dispute it, but that doesn't go to its admissibility, it goes to its weight.
No, its admissibility had to do with the court's previous assessment, which was that the fact that Eric was there to facilitate his uncle Carlos, or cousin Carlos, wanting to know what was on the will, was not admissible.
On the theory that it related to the defendant's efforts to find out about the will, and it didn't. But now the people are offering this other evidence for a different purpose.
And is the jury told what the purpose is? It doesn't have the same prejudicial effect of making them think that he's there because it's that he is the instigator. Because Carlos Menendez, for example, is not on the people's witnesses.
No, I think Mr. Heyman would so testify, and he did testify before the grand jury as to how he got there. It was through Carlos Menendez, and that it was because he worked for the same company. So that's all before the prior fact that he went there, and that was presented to the grand jury, that Erik Menendez just happened to be there and let him in, and just stood there as he went through the computer, showed whatever interest Mr. Heyman described. But that doesn't result in any prejudicial evidence being introduced to implicate Erik Menendez. It's just an event that happened. And it documents the people's theory as to the date Cignarelli spoke with your client, and your client made these admissions. You dispute that. That's for the jury to decide.
The dispute in question, however, has to do with these conversations appearing on page 17 and page 18 of the May 7th transcript.
Well, that's the dispute that we're talking about now, as far as specifically what it was that was told to Mr. Cignarelli by your client,
Yeah.
rather than
And
what
when?
Mr. Cignarelli surmised from information he received from the police or other sources.
It's also not clear from this when he was told anything by Erik about Lyle and erasing, or Erik wanting to see a will, whether that's told at the time Heyman is there or whether that's told much later. It's not clear from this transcript.
All right, well, that can certainly be resolved when Mr. Cignarelli testifies.
Well, but it may not be relevant. He didn't know anything about it at the time.
Well, that can be asked. Ask Mr. Cignarelli, what did, if anything, did Erik Menendez say about the will that day? Simple question, get a simple answer. He could say nothing. Nothing was said. Or he could say whatever it was said. All right, what's the next issue of objection?
Page 24, again relates to burglaries, bottom here.
Okay, again, that'll have to be deferred, and it might cause Mr. Cignarelli to be called back at some later time, depending on when the people and the defense submit their briefs on the subject. As far as any opinion Cignarelli has on page 25 is relating to motive, I assume the prosecution is not offering that.
That's correct. Again, page 26, they're not offering the great leader statement. Now, Your Honor, I was objecting to this statement of that $80 million in Swiss bank accounts. It says they supposedly have about $80 million sitting in Swiss bank accounts, but I decided to withdraw the objection. I think that sheds a certain amount of light on Mr. Cignarelli's thinking. And along the same lines, his reason for believing or thinking that there's $80 million in a Swiss bank account is because he has heard that Mr. Menendez was financing a $50 million drug deal, and I think that's staying.
I didn't intend that.
Well, but he did intend to offer the $80 million. So if he's going to do that, then I think we're entitled to show what his speculations about drug dealing is.
Whose speculation?
Mr. Cignarelli.
Well, obviously, it's just that, speculation.
So is
And
the $80 million.
if there is nothing based on fact, that is what Mr. Cignarelli knew from firsthand knowledge or statements made to him by the defendant, it would not seem to be admissible evidence as far as the amount of the estate or the source of the money in the estate.
Yeah, I think it should not come in just as the statement that he indicated regarding how many was being cocaine dealer should go out. So I don't think any of that speculation coming involved.
All right,
Including the speculation that $80 million was Swiss bank account?
he's not offering it.
Okay. When we get back on page 27, Your Honor, obviously apart from objecting, but I don't know if this tape could be played or if it's just information from it that the people would be offered. So I X'd out the comments of Mr. Cignarelli's attorney. But on the bottom, we're back to the screenplay.
All right, well, we'll get to that.
And then there's also a discussion about the new screenplay, which begins on page 28, which the court has ruled on. And that goes on through 29. To page 29, the second screenplay. And Mr. Kuriyama agrees that page 30 is out.
All right. So anything else now, other than the issue relating to the screenplay?
Oh, yes, but we can't deal with this afternoon. There's that tape recorded, wiretaped conversation of November 29th, 1989. And we have a lot of objections to a lot of what's in here. The bulk of this transcript that the people seem to want to use is Erik explaining to Mr. Cignarelli the entire plot of the second screenplay. And obviously, I think Mr. Kuriyama now concedes he isn't going to be able to offer that. But there's many other parts of this that we think has prejudicial and irrelevant material. And all I can suggest is this. Mr. Kuriyama marked a copy in yellow of what he wants to, so let me strike that. The yellow is what he doesn't want to prove. The unhighlighted is what he does want to prove. And we have objections to much of what he does want to prove from this transcript. But the only way for the court to get a sense of this is we have to read it.
Well, I've listened to the tapes of this conversation and I looked at the transcript. What I haven't seen is a copy of the transcript that has been marked by the parties indicating those things that the prosecution intends to offer to which the defense objects. The defense has given me a copy of the transcript highlighting those things that you object to. Which doesn't help me very much because I don't know if the prosecution is even offering that.
Well, all we can do is give you the prosecution's highlighted part, which is what they're not offering, and
No, you can give me a combined effort showing me in a finalized version those things that are being offered that you object to. I can't go through 100 or more pages and compare page to page and try to figure out what is being offered by one side and objected to by the other. You can give that to me.
what I can do is I can take this copy that the prosecution gave us, which has the portions that are not highlighted are what he wants to use, and write our objection in the corner.
All right, there might be things that you don't object to. I assume there are.
Yes, there may be, but it's not likely.
Well, in looking at what you submitted to me, those things you objected to, there are some things that might be rather frivolous, so I don't
Our
intend,
objections were frivolous or the evidence was frivolous?
both.
Yeah, there's a lot of frivolous stuff in here, that's why
Well-
we object to it. Chicken hearts and, swordfish and.
Yeah, they were at a restaurant and they were ordering fish and somebody asked for some extra lemons and then you objected to that. So what, are we gonna spend court time on that?
No, but the people can not offer extra.
Well, I assume they're not offering the tape, they're offering the substance of the conversation as testified to by Mr. Cignarelli. The tape isn't being played, so I'm not gonna get into a discussion of all that extraneous material.
That's correct, Your Honor.
You get to the heart of it as to what it is that is being objected to, that is being offered by the prosecution and let me know the specifics of it rather than
All right,
submit
well,
something
what
like
I will
that to
do
me.
is, what I will do is mark those portions that he says he's offering that we think are objectionable.
All right.
And give you that marked copy.
Okay.
And
That's what I really assumed that you were doing. That's what you had told me you were going to do yesterday.
but he didn't give me what he's offering until today. Your Honor.
Okay, well, then I assumed that you would have had it done so that we could have
Got
that
it
copy.
new.
Okay.
And I got here and went through it when we were waiting for you. I
Yeah.
went through all of it, so, but
But I don't have it.
my scrawl, so I'm gonna clean them up.
All right, I haven't been presented it, so I can't really look at it. All right, so what I don't intend to do is get into a lengthy hearing on Monday before testimony begins with Mr. Cignarelli before the jury. So the matters had better be clearly delineated. If you want, we can take brief testimony now from Mr. Cignarelli regarding the screenplays,
Right.
and that'll be it. You ready to proceed?
Yes, Your Honor.
Okay, let's get them.
Craig Cignarelli,
What are you asking for?
Cignarelli.
All right, Mr. Kuriyama?
Thank you, Your Honor. Mr. Cignarelli, do you know the defendant in this case?
Yes.
Would you point him out?
We'll stipulate he knows.
Yeah, let's get to the merits here.
How long have you known him?
6 years?
I want to draw your attention to approximately January 1st, 1988. Were you with the defendant on that date?
Yes.
And what were you doing on that date?
We were at a mountain cabin in Fraser Park writing a script.
And what was the script?
It's called Friends.
What was it about?
It was a murder mystery. You want the whole script?
Just
Your
a
Honor,
summary of it.
I don't understand it. We know what the script's about. Read it.
All right, well, I assume there was more than one version, but the issue here relates to those first couple of pages, Mr. Kuriyama.
Yes, just very briefly, a summary.
A kid looks at his inheritance, opens up a will, sees his inheritance, and sees that he stands to gain $187 million, goes upstairs and kills his parents.
Now, did you write this? Did you and Eric write this?
Yes, we co-wrote it together.
Could you describe for the court how it came about?
We brainstormed and wanted to create a murder mystery. And basically the entire idea was mutual. We went through a series of scenarios. Actually in the script, the best friend is blamed for the murder at the end of the story, or is set up to be blamed for the murder.
This is a collaborative effort.
Correct.
I have nothing to.
All right,
Was this the first time, January 1st, 1988, that you and Eric had ever even talked about writing a script?
No,
And when had talk about writing begun?
I don't know.
How long before this?
I don't know.
A month?
I don't know.
A year?
I don't know.
How long had you known Eric before this?
When he came to school, he was in 10th grade. I was in 11th grade.
When was that?
1986, I believe.
So you knew him for at least a year and a half before this trip to, this was your cabin, I think?
Correct.
Your family owned it?
Correct.
And there had been some discussion before this about writing scripts?
We had discussed writing screenplays, yes.
And had you discussed writing a murder mystery screenplay?
I don't recall.
Had you done any previous writing work on a screenplay before you, together, or written bits to show each other before January 1st, 88?
Oh, we might have. I truly don't recall. I know that at the time, we had come up with the plans for the entire script at that moment for the script of Friends. We may have written some stuff about a murder mystery before that, or some ideas about screenplays.
So you're saying the entire every idea that appeared in the transcript began on January 1st, 88, is that what you're saying?
No, it was during those few days when we were up there writing,
You were there 3 days, huh?
approximately.
And the whole thing was written in 3 days?
Correct.
And everything that was written in those 3 days occurred to you for the first time in those 3 days, is that what you're saying?
Everything that was written for the script, yes.
Okay. And was it written like from the first words to the last words with no changes, just straight?
No, absolutely not.
Now, you're saying you don't have any idea which one of you first came up with the idea of having a script in which a kid kills his parents, is that what you're saying?
That's correct.
So it could have been your idea first.
It was both of our ideas. I mean, we discussed several methods of a murder mystery, and both of us kept throwing out ideas over and over and over.
And you don't remember which one of you first threw out the idea about a rich kid.
That's correct.
Could have been you.
Could have been.
Do you remember, in fact, that it was you, Mr. Cignarelli, who thought of the scene itself of the kid actually reading the will, making that an active scene in the screenplay?
I don't recall.
Could have been you.
Could have been. Yes.
Now, when you were working on this screenplay, were you and Eric talking about either or both of you killing your own parents?
No.
Did that ever come up?
No.
Did you talk about your parents at all while you were writing this?
Not that I believe. No.
Did Eric ever talk to you about killing his parents before his parents died?
No.
Did you ever talk about killing yours?
No.
Did he ever complain about his parents?
No.
Did he ever say he hated them?
No.
Did you ever complain about yours?
Yes.
Okay, did you say you hated them?
No.
You told the police on March 7th.
Objection, Your Honor.
Does it relate to the
It
screenplay?
doesn't.
All right.
You told the police, Mr. Cignarelli, on March 7th, 1990, that this screenplay had nothing whatsoever to do, as far as you were concerned, with the killing of the Menendez parents.
That's correct.
And in your mind, when you and Eric were working on this screenplay together, you didn't think it had anything to do with real life, did you?
That's correct.
In fact, Mr. Cignarelli, didn't your mother and Eric's mother type this script, work on it for you guys?
Yes, they did.
Both mothers shared the typing duty?
Yes.
And you yourself felt, didn't you, that this was, a first effort, a sort of immature, amateur effort on both of your parts?
It was a formulation of ideas. It was the first screenplay together.
And you didn't think it was a polished piece of work at that point?
No.
That's what we're doing.
Overruled.
And I think you told that to the police also in March, that it was just a rush effort to just get a bunch of ideas down on paper.
No, it was a script.
Mhm.
It wasn't just a bunch of ideas. It was a formulation of a scenario. It wasn't just a bunch of rush ideas.
Do you have any recollection whatsoever about how the issue of a will even came up in your discussion with Eric? Do you have any idea what inspired either of you about that?
No, I mean, that we wanted the setting to be a wealthy person.
You wanted your protagonist, this Hamilton Cromwell character, to have a lot of money.
Correct.
It's that way you could write exciting things, you could travel, you could do things, right?
Correct.
So the whole idea was to figure out how could he, and he wanted to be a young guy, because that's what you were interested in writing about.
Correct.
So it wasn't the idea, how could a young guy have a lot of money?
Right.
And out of that sprung the notion that, well, he has to have dead parents.
Correct. Or formulate a business or something. I mean, like I said, we went over a scenario of ideas and
The
this one.
basic idea was a murder mystery anyway.
Right.
That's where you started even before you came up with this particular kind of murder mystery.
Right.
Have a motion. I don't have anything further this time.
Any redirect?
Thank you, Your Honor. Mr. Cignarelli, it could have been that Erik Menendez thought of killing the parents in this screenplay, correct?
Correct.
It could have been Erik who thought of inheriting the money and killing the parents for the will.
Correct.
When you were working on the screenplay January 1st, 1988, did you have any idea that Erik Menendez would be killing his parents a couple years later?
No.
I'm not control this.
Anything else? Okay, thank you. May step down. Excuse until Monday.
Yes.
All right. Did you wish to argue the matter, Mr. Kuriyama, as to why this is admissible evidence?
I believe it's been established that Erik Menendez was a collaborator on this screenplay. I think that the fact that he was involved in writing the screenplay shows his knowledge that both parents would have to be killed in order for a person to inherit. I think it's relevant on that basis.
Is that really something that requires someone to write a script to have such knowledge, or is it pretty common knowledge that even could be imputed to Mr. Menendez, Erik Menendez, without use of the script?
I don't know whether that kind of information can be imputed.
I mean, the average juror would assume that Mr. Erik Menendez wouldn't be aware that if both parents died, that he might inherit.
Well, I think the fact that the people have a burden of proof in that matter, we wouldn't want to assume that we have to establish that. In as much as under these circumstances, where he himself kills his parents and has written a screenplay where the protagonist has done the same thing, I think the relevance is great.
Okay, now you're going beyond what your offer was. Your offer is that it would show that Erik Menendez knew that a person whose parents both died could inherit under a will. Now you're arguing that the fact that he wrote this screenplay is circumstantial evidence that he killed his parents for the money, which is a separate issue. It doesn't go to knowledge that someone could inherit. It now goes to his state of mind when the killings occurred. So it's a separate issue. Is it not?
I believe so, but I think there are many factors that go into the mix as to its relevance.
Okay, well, I asked you, what is your offer of proof? And you said it goes to prove knowledge. What else is it offered to prove?
Well, it's offered also to prove his state of mind when he committed the murders of his parents. He knew that he could potentially inherit, and we have evidence that this supports and substantiates that he, in fact, one of the motives for the killing was to inherit. In addition to that, the court has ruled with respect to 352 about a later screenplay.
Well, the other screenplay was just very long, convoluted, amateurish, puerile story that related to all sorts of activity unrelated to killing one's parents for inheritance. It related to fantastic activities such as freezing dead bodies and their preservation somewhere on some desert island and all sorts of things that have nothing to do with anything. It was just totally extraneous and would go on ad infinitum in a hearing before the jury on extraneous matters that would be totally inadmissible. That we would spend hours and hours hearing theories of literary merit and things of that sort that have nothing to do with the defendant's state of mind at the time the crimes occurred. That's why that was excluded.
That screenplay was over 100 pages, and I agree with the court that there was a lot of things that would not be relevant to the case. But that screenplay, like the first screenplay, had to do with a young man, 18 years old, killing his parents.
As I recall, and that screenplay ultimately was determined that he had not killed his parents. Someone else had.
No, that was not. It was. It's if you look closely at that particular screenplay, as he's writing the screenplay, he's stating that no one knows that the hero is in fact the killer of his parents. But by saying that, it shows that he was in fact the killer of his parents. He was trying to fool the audience, and he may have fooled other people. But the screenplay itself indicates that he, the protagonist, was the killer of his parents. And I agree with the court wholeheartedly that the killings of all these other people in that particular screenplay would not be relevant in this case. But I think, as in the first screenplay, the first couple of pages where the young man kills his wealthy parents, I think that's relevant.
Okay, again, it's relevant to prove what?
It's relevant to prove Erik Menendez's state of mind, his knowledge about both parents having to die in order for him to inherit. Those are basically the two reasons why I think it should be admissible.
All right, and the defense response.
You know, what's interesting, Your Honor, is in the Friends screenplay, both parents do not have to die for Hamilton Cromwell to inherit. It's a specific bequest from his father. So that theory doesn't really work. Number one. Number two, obviously we agree with the court's statement that you don't need to have written a screenplay to know about inheritance and wills. Moreover, the people have other evidence. They have supposedly Dr. Rizzo saying that there was something in the family about disinheritance. So clearly Erik had some knowledge about inheritance and disinheritance. And they don't need the screenplay to prove that he had some notions of that. And finally, and it will try to use, as we briefed very extensively, a work of amateur fiction for which Erik cannot even be held to have thought of these concepts, according to Mr. Cignarelli's testimony. And to say that you can race that forward a year and a half and prove the state of mind of someone when he commits a homicide, it's just stretching it too far. We briefed it extensively. I don't see the point of arguing it before again. It just doesn't seem sufficiently relevant or probative to outweigh the prejudicial impact or potential impact.
All right, anything else?
Yeah, I think the fact that Erik Menendez revises the screenplay some 1.5 months after the murders, inserting things such as adding a library in the screenplay, adding a chase scene of the mother in the screenplay, I think those are relevant to his state of mind. It shows that this screenplay, that he saw himself as a hero in the screenplay, in my opinion. In that, in the actual killings, Erik Menendez said his mother was moaning and trying to crawl away. Well, in the screenplay that he then revises from the original Friends, he puts down things such as a chase scene of the mother, where he has to chase the mother throughout the house and then over the lawn, and then finally catches her and kills her. So I think that makes that shows his connection, his state of mind with respect to the screenplay.
All right, well, a lot of that might have some merit in cross-examination of Erik Menendez as to his state of mind. Possibly, I don't know. It's certainly an area that might be explored. But your offer is that this should be presented to the trier of fact in your case in chief to show knowledge that wills produce inheritance and state of mind of an intent to kill the parents. At the time it was written, that this was his state of mind.
Well, not at the time it was written.
Then at what time?
At the time when the killings occurred, he had that information in his mind.
That he wrote it a year and a half before and was thinking about it at the time.
Yes.
Is there any evidence whatsoever of that?
Well, there,
It's almost, isn't it almost like taking a reading list of all books that somebody has read and with all sorts of fantastic stories in them, and then going back and looking at a specific act that was committed by that individual and say, well, if we want to know what that state of mind was, or the individual state of mind at the time that act was committed, we can go back and look at all the things the person has read over his lifetime. And if there is something that remotely or even less than remotely relates to that incident, it would be admissible evidence.
I think if Erik Menendez had written stories such as Chip and Dale go to Wimbledon, I don't think that would have any relevance. But in a case such as this, where the facts of the actual murders are mirrored in a screenplay, which he not only wrote and so had in his state of mind at the date that he committed the killings, but also one that he revised some month to month and a half later, in which he changes the screenplay to comport more precisely with the actual killings. And in fact, in that second screenplay, he puts down that the secretary of this hero who has killed his parents is named Marcy. And in fact, his father had a secretary named Marcy. So there's so many connections to real life as far as the screenplay goes that I think it's totally connected with his state of mind.
Your Honor is right. Now he is looking back through everything he knew and did to see that something actually
All right.
was magical thinking.
Okay, I am going to reread these two screenplays and give you a ruling Monday morning at 9 o'clock.
Thank you.
All right, but I don't intend to go back and relitigate that second screenplay. It still has so many extraneous matters in it that it's not relevant, and any relevance would be substantially outweighed by its undue consumption of time and potential for confusion of issues. Likewise, that's a concern the court has here, because whatever you think you might be asking Erik Menendez if he and when he gets on the witness stand, the defense would be asking of Craig Cignarelli as he's on the witness stand. And we can go on for hours listening to how that screenplay was written by Craig Cignarelli and Erik Menendez, and we can go on and on and on. And although your position is that Craig Cignarelli did not kill his parents, but Erik Menendez did,
Yes, Your
still that involves a substantial area of inquiry that would be of concern to the court, and that would consume an undue amount of time and confuse a lot of issues in this case and not really prove anything. So I'll review those two scripts once more, but I'll give you a ruling first thing Monday morning. And at that time, I want also the document that reflects the defense objections to the specific items offered by the prosecution in that interview, or that conversation that took place between Cignarelli and Erik Menendez on when was it, November, in the restaurant in Santa Monica.
If I understand the court, the previous ruling on the second screenplay is still with you.
Yeah.
So what I think we'll do to make it easy for the court is we'll just cut and paste pieces of that. We'll give you the page numbers, but the pieces of that transcript that the people do want to go forward with, and give you our objections to that, so we're not handing you back a big.
Yeah,
set.
that's all I want, is those things that specifically are being objected to.
We'll get that, and we'll get that to the court first thing Monday morning.
Fine. And see if we can get it here at 8:30 so that we don't waste any time once the jury is here. There shouldn't be much time before the jury is in a box and Cignarelli is on the witness stand.
Okay.
Any further refinement other than what could result in lengthy examination regarding the screenplay? Any other than that, keeping that separate, what is your time estimate for Cignarelli's examination?
Direct examination probably an hour, hour and a half.
And Your Honor, he's not gonna be permitted to testify to anything about burglaries.
No, as I said, that hasn't been briefed. This is the first time anyone's really brought it to my attention, so he'll have to come back later if that is admissible evidence. And the defense has indicated that you wouldn't have objection to portions of it being admitted, so it might very well come in one way or another.
Well,
We have other evidence establishing burglaries, between officers and victims. So.
Well, I'd have to see what it is you have to offer.
Well, that's the kind of evidence that I am objecting to, the officers and the victims and relitigating the burglary stuff.
Yeah.
I think the court understands your
Yeah.
position. I'm just trying to think for a moment, what would the other? Well, I know.
Anything else?
No, As far as the length of the cross-examination, obviously, if there's gonna be no reference to the screenplays, it's going to be shorter. There's gonna be some reference to the screenplays, it's gonna be longer. And where are we exactly now on the will stuff? Is the court's ruling that Cignarelli can testify he was there when this computer person came?
Yeah.
And whatever Eric said to him
Yeah.
about the will?
As long as the people make clear by the testimony of Mr. Heyman that he was hired by and was there at the request of Carlos Menendez, and that Erik Menendez just happened to be there. Or was there at the request of Carlos Menendez.
Oh, what are we gonna do about perfect crime?
I'm sorry.
You want me to find the perfect crime?
Yeah, you said you have a case that specifically deals with that.
That's what I've been told, and I will find it if we can.
Okay.
But that will, okay, so we'll try to get a ruling on that before we start.
Yeah, if you can give it to me at 8:30 so that we can get going.
I have to go out and write it first.
Anything else?
No, Your Honor, thank you.
Okay, we'll be in recess until Monday. As attorneys and the people are represented, Mr. Kuriyama, did you submit anything to the court today in regards to the testimony of Craig Cignarelli?
No, Your Honor, I submitted the November 29th, 1989 conversation on Friday, and I received this morning the defense objections to that taped conversation.
Well, we did object to it, we went over the objections of Mr. Curran on Friday, we just wanted to put it in a needed form. This morning.
Yes, you received that Friday, Mr. Kuriyama, and we discussed it Friday. And the purpose of the submission today was so that the defense would document their objections to the specific things that are contained herein.
And what we went over was the March 7th interview with Cignarelli.
Yeah, we went over that in open court, but the defense had given you their objections to the November 29th conversation prior to that hearing on Friday, did they not?
They did not.
You never saw it, never had a copy of
I
it?
got that this morning, just when I came in today.
You never got it Friday?
This is when I got it.
We discussed with Mr. Curran extensively our objections to every aspect of that transcript.
All right, well, we had this byplay back and forth that the defense had one version, you had another version. Each version had your respective positions as to what was or was not admissible, and the defense was going to combine the two, and that's what we have today. And you never saw the defense objections, and they never saw your proposals, is that what you're saying?
No, the proposals I submitted to the court in the highlighted yellow. I indicated that I would not question regarding those matters on the 29 tape. I gave a copy of that to Ms. Morrissey on Friday afternoon after court, and I received this regarding their specific objections this morning.
Your Honor, before the court took the bench Friday afternoon, I sat down with Mr. Curran and went through, as I had just done over lunch, his transcript, when we went over which pages he wasn't going to offer at all, and I showed him everything you were objecting to, so I really think it's inappropriate for him to pretend he didn't know what our objections were.
Well, he's not saying that, he's saying he never received the document itself.
Well, he didn't give us a proposal.
All right,
Friday.
regardless of that, I don't want to get into nitpicking and fault finding here. Are there any matters other than the screenplay that must be resolved before the witness testifies?
Yes, Your Honor, there's the things that we filed with you this morning, the unresolved, which we had, all of which have been discussed on Friday.
Well, a lot of those things have been resolved.
Well, there's the burglaries issue.
Well, that was going to be held in abeyance. People were just filing something today, and I haven't reviewed it. They filed probably 100 pages worth of documents
Exactly.
at 9 o'clock this morning.
There's also under the November 17th statement, the perfect crime, ruminations.
Yes, you were going to give me a case that dealt with that subject.
Well, you know what it was? I misspoke. There is no case that dealt with that subject. What had flashed into my mind was that I had had another trial where that same kind of discussion came up, where a friend of the defendant claimed the same sort of rumination. And it was just at the time that the Rodriguez case had come out. And this is of no precedential value for this court whatsoever, but that trial court determined that
Since it's no precedential value, you shouldn't tell me what that trial court
Okay,
did.
then I won't tell you what they did, but I think this court can reason that this kind of generalized, vague information about ruminations about crime is bad character evidence that does not come in any exception to 1101. And I gave you the citations from Rodriguez because that shows the completely opposite situation. When there are specific threats to commit a specific crime and the victims in the case come within that class of victims against whom a defendant has been making what sounded to all who heard them to be genuine, intentional threats to kill police officers if they ever try to arrest them. And I just compare and contrast that to two teenagers dreaming about committing perfect crimes. So that issue is still open from both the August 24th and the November 17th interviews. Obviously, the witness's concerns about himself, his personal belief about guilt.
Okay, we've discussed that, so let's not go over things we've already discussed on Friday.
I do think we did discuss personal belief, but I'm going to assume the
We did.
prosecution wants to.
We did, as far as his belief as far as why the killings occurred. That was inadmissible.
And then on the November 29th tape, we have all of this supposed financial gain information.
Well, as I said, the financial gain issue is one that the court has preliminarily ruled upon, that it's admissible. The specifics of it has not been ruled upon because you have certain objections and you want to have an evidentiary hearing where you'll call one or more witnesses to testify about certain transactions. And since we haven't gotten there yet, the court will not rule on the specifics of what would and would not be admissible until then. And if it requires the reappearance of Mr. Cignarelli for that purpose, then he'll go back.
Okay, there are a whole list of items, Your Honor, from the November 29th transcript that the prosecution indicated it wanted to go forward with, and skipping around away from the spending one. Item 2 is Mr. Cignarelli's statement that the Genevieve, I don't know what that is, family was a suspect in Erik's response. This is Mr. Cignarelli injecting this into the conversation. Organized crime, we object to that. Erik's changing his hair color because he took some modeling photographs and failed to see the relevant.
Look, is this all stuff that the prosecution's offering?
They were offering all of it.
Yes,
You're offering his change of hair color?
For example,
For what purpose?
it's my contention that Erik Menendez was an aspiring actor, that this conversation that he had with Cignarelli indicated that he was doing model shoots, he was dyeing his hair in preparation for his acting career. In addition, it appears that he had taken drama lessons and had won an award for acting, apparently at Beverly Hills High School. So that, I believe that's relevant to that aspect of the case.
And this is contained in the transcript that he had won an award in a drama
Not
class?
that, but that will be testimony.
Well, what does the change in hair color have to do with anything?
What he's discussing is his model shoots.
What does that have to do with acting?
Well, that's part of the profession, I believe, that he was preparing for modeling and for acting.
All right, it doesn't seem to have any relevance as offered, and the defense objection is sustained as far as changing of color of hair, unless it had something to do with trying to avoid arrest or apprehension, something of that nature, which obviously, from what you're saying, does not.
Item 5 is Erik's reference to a pager. It has no connection to anything. It's not relevant to anything.
You offering that?
The offer with respect to the pager has to do with his aspirations to be a big shot businessman, and he carrying a pager around and having to call him. I think it's all part and parcel of this, these huge plans that Erik Menendez had with respect to big business.
Your Honor, I think that the people's fractured theory is very obvious. If he was going to be an actor, he was going to be a businessman. I think what they're really trying to do is just throw every single piece of evidence that might raise some inference of big shot, which is character evidence, at him. And that does not fit any relevant use of this evidence, which is supposed to show motive 3 months before.
Let me ask the prosecution, there's a whole list of these objections. They go on for several pages here relating to the November the 29th conversation, and then go on to other conversations as well. Have you reviewed these?
Yes,
And do you intend to offer each and every one of them?
I had intended to offer everything that I did not highlight in the statement that I presented to the court, yes.
Which is what these are.
All right, and the statement that you highlighted is supposedly this statement here?
That appears to be yes. All the yellow highlighted areas are areas that I did not intend to get into.
Well, this is the November the 29th tape recording. You intended to offer all of this? This was a document presented to me by the defense. The highlighting is the defense highlighting.
No, Your Honor,
No, that
that's
is my
the
highlight.
document
That's
from
what I was
Mr.
referring to.
Kuriyama. The highlighting on that indicates what he's not offering. The unhighlighted is what he is offering. Our document has taken out what he's not offering and only gives you what he is offering with our objections written on the margin. So ours is slightly smaller.
Your Honor, we did take out from the submission that we presented to the court this morning, any reference to the second screenplay. Kuriyama did indicate in his submission that he wanted that in. I spoke with Mr. Kuriyama, and I think we would agree that the court's ruling that the second screenplay does not come in precludes the admission of those portions of the yellow highlighted transcript.
Your Honor, the problem that I saw was that in the conversation on November 29th, Erik Menendez admits or acknowledges that his second screenplay was modeled after his life. And so that's the problem here. Because
Okay, the court has already ruled that the second screenplay is not admissible, Mr. Kuriyama.
Correct. But the statement that he makes has no meaning unless the second screenplay is referred to.
Well, then that statement doesn't come in. The problem I'm having, Mr. Kuriyama, is that, and I don't understand, maybe you can enlighten me. You have a conversation that took place between Cignarelli and Erik Menendez. They were sitting there having dinner, talking about everything in the world, all sorts of things. Many things have nothing to do with this case. And you've gone through that conversation and you've excised a very small part of that conversation. And then you, by doing that, are indicating to me that everything else in that conversation would be offered by the prosecution. Is that true? Is it your theory that because Craig Cignarelli asked or said something to Erik Menendez when there was a response during that conversation, that makes it something that should be brought out in this trial? Anything and
Your
everything?
Honor, if I may clarify, see what the court's concern is. What I believe was my task was to excise that which I didn't think was relevant at all. Now, some of this may become relevant upon Erik Menendez taking the stand, and I get questioning on those.
Some of
matters.
what? Some of the stuff that you've
Some of the-
excised?
No, some of the statements that are within that which are not excised.
Okay, all I'm
I'm not
talking
saying-
about now today is what is that which you are offering to this jury from Mr. Cignarelli when he gets on the witness stand today? That's all that's at issue here at this point. Nothing else. So,
Generally speaking, what I wanted to get at was the spending plans that the defendant had, his statement that the Cuban hitmen were responsible for the killing, his admission to and request of Craig Cignarelli that he not tell the police what Erik had told him, as well as his plans with respect to acting. Because generally speaking, his plans of spending, and as he reflects on the purchase of the Jeep, refers to the Marina Del Rey apartment. much of this, as the court has indicated, the court has decided that the second screenplay doesn't come in, and much of this refers to that because much of this conversation is describing for Craig Cignarelli the second screenplay. So
Listen, there's no problem with the reference to the fact that they were sitting there. If the prosecution wants to get into discussion of why they were at the restaurant, what they were doing there, there's no problem with the prosecution bringing out that they spent a lot of time discussing a screenplay that Erik Menendez had written. That's certainly not prejudicial, just that the court has ruled that the content of the screenplay is not relevant or probative and would not be admissible. But certainly you can mention the fact if it's relevant or relates to what is otherwise being introduced. You can refer to the fact that they spent time talking about a screenplay. But the content of that conversation doesn't have any relevance to these proceedings.
That isn't what this whole list of things is. I mean, this list ranges over the entire discussion with things that can't have any possible relevance. And I thought the court had just said that specific purchase information cannot come out at this time, so we have our hearings. But we have been very specific in our objections, and if the prosecution is not gonna concede that this stuff is not relevant, then I'm sorry, but I think the court has to go through it item by item and make a ruling.
Well, you're sorry, but that doesn't mean the court has to do it. It means that you want the court to do it.
Well, we've made an eliminate motion, we brought the issue to the court, I
Yeah.
don't know what else we can do to get
Well, a lot of,
specificity.
quite a bit of this material is material that could easily be subject of objection and ruling if the prosecution seeks to elicit it. My feeling is that most of this is not the material that the prosecution would be attempting to bring out during the examination of the witness.
But that's why it's here, because Mr. Kuriyama told us, yes, indeed, he specifically intends to bring out everything on this list, we're not fishing.
No, he didn't. He didn't go through this list and say, I intend to bring this out. He created the list and then you threw it under his nose and he said, yeah, that's all in the conversation, so I'm going to introduce it.
No, Judge, I'm sorry, let's disagree with you. We sat down and discussed, do you really intend to bring out this? Yes, I do. Do you really? I mean, we really did. And he's insisting that.
Hold on a second. Okay, in the future, I don't have any problem with the jurors making a little noise in there. It's quite fine. They can talk if they like.
I just thought it might be getting loud for.
No, it's actually good that they talk so that they're able to carry on their own lives while we're doing this.
Judge, this is not our hunting through this transcript for things to throw up. This is what Mr. Kuriyama told us he really intends to bring out with this witness. So if he doesn't, I wish he'd tell us what to get on with this.
As I told counsel, I believe on Friday, there are things that I believe may become relevant later in the trial when, for example, Erik Menendez were to testify. Now, I told defense counsel that I didn't want to excise everything. Some of it clearly should be excised and would never come in for any purpose. There'd be no reason to. But some of this information may come in later in the trial, and I didn't want to excise it so that she could say, well, wait a minute, you agreed not to use that.
Okay, well, just focus on what we're here for today. We have a jury. The jury was told to be here at 9 o'clock. It's now 9:40. And the purpose of today's proceedings is to have testimony on the people's case in chief against Erik Menendez, and the witness would be Mr. Cignarelli. Now, the issue is whether or not these things that are objected to by the defense are going to be introduced by the prosecution in its case in chief during the examination of Mr. Cignarelli today.
May I go down this list then now?
Yes.
Starting the November 29th, 1989 court conversation. The court has, with respect to number one, the spending, I will wait until the court makes a ruling on that, so that is out. Two, with respect to the reference to the mafia, apparently Erik Menendez had indicated that the mafia was involved in the killing, and I think that is relevant in the case because it shows that he has continued to lie about his own participation in the killings. Number three, the changing of
Let me
his.
just address that for one moment. The way this comes up in the conversation, they are talking about someone else, a friend that they know. And it comes up in the conversation on page 5 that this other person has some connection with the Genevieve family, okay? It's nothing to do with Eric making up a story about this case. Then it is Mr. Cignarelli who says, and from what source he has this, I don't know. Wait a minute, I thought the Genevieve family was suspect. Doesn't even say suspect in law. Eric says, yeah, it is, but it's his godfather, his god. They're talking about someone else. So this does not even support that theory of admissibility.
All right,
It just doesn't work. That because the mafia is mentioned, that means that Eric's trying to throw blame for this to the mafia. This is, after I was talking to the person who confessed in here.
Here, if I can clarify.
yes.
I believe that part of the problem is that they're talking about areas of, that I may question on. And this reference in this transcript had to do with an earlier statement by Erik Menendez about the mafia being involved in the killings. So I think counsel is correct that this particular reference may not state exactly, but the witness will be testifying from the witness stand, and he can fill all that in. So if the counsel is directing her objections specifically to this rather than areas of my inquiry, then that's different. There's a distinction between the two.
Well, that seems to be what the defense is doing. They're objecting to a specific conversation that occurred on November the 29th.
Moreover, Your Honor, there's no previous statements to this witness by my client that I have ever received discovery of that the mafia was involved. That is not a discussion that we have been given notice occurred between my client and this.
That's a separate issue. That's not before me at this point. The issue is, as you've objected to certain things that occurred during the November the 29th conversation.
Well, I couldn't object to any mafia reference made of the statement because I don't see it. So if the people are going to elicit that, then I'm asking for discovery of it since I've never.
I'm not going to rule on that. That's not before me. You've made objections to the November 29th conversation. I'm not going to, as I said, I'm not going to take a deposition from Cignarelli, and I'm not going to rule on every little piece of evidence that is going to be offered by him in his testimony in advance.
All right, so that's 2. That's out.
The people aren't offering it.
3, the court has ruled is out. The spending is 4, that's out. Reference pager and business, I believe the court has stated is out.
I didn't rule on that. That's part of the spending evidence again, so we'll just keep it all together in one focused area of presentation by the prosecution.
Number 6, I believe this statement demonstrates Eric's friendship with this particular witness, and I think that's important to demonstrate for the jurors.
I don't think there's any question of their friendship and no one's going to claim anyone twice.
All right, the prosecution can introduce that.
Number 7, there has to be a spending now. The speed trips is out for now. Number 9 is out for now. As is 10. As is 11. As is 12. 13. With respect to 14, it is apparent that Erik Menendez had told Craig Cignarelli that he was carrying a gun around, apparently for his protection from the people that killed his parents. I think that is relevant in this case when he, months after the killings, is still claiming that it was someone else and that he fears the people that killed his parents, when now he's claiming he was acting in self-defense. I think that's very important.
Well, Your Honor, the part we object to is, I mean, in this conversation, Eric basically recants his confession to Cignarelli and denies it. So that's the evidence that I think is relevant to the point that the people are making. The fact that he's talking about carrying a gun, we think the prejudicial impact outweighs the probative value when they already have Eric denying to this witness that he killed his parents.
Well, obviously, if the defendant was indicating that he was carrying a gun to protect himself against the people who killed his parents, that would reflect on the defendant's state of mind and his continuing conduct of lying about the true circumstances of his parents' death, and would be admissible evidence.
Well, Your Honor, we think that his state of mind at this time and whether he was lying about it to this witness is of minimal relevance when he's already confessed to this witness. Unless the
Well-
witness is lying.
Well, you're going to dispute the confession, I
No, we're not.
suppose. None of the details of it? You're going to accept everything that Mr. Cignarelli says your client said to him?
Well, except for details that he would probably admit he's not clear on.
All right. Well, again, this goes to weight of the evidence, not to its admissibility. And if you have some problem with whether you think it's highly probative, you can certainly argue that to the jury.
Your Honor, I think 15 can go out. And with respect to 16, that was not Mr. Cignarelli suggesting that the deaths were non-related. That had to do with Eric's statement, my understanding.
But why don't you read the transcript?
Okay, counsel, let's not have this byplay back and forth. If you have something to say, address the court rather than counsel.
Oh, yeah, Your Honor, the way it reads, it's B 17 of 33. And it says, it's Craig brings up, do you think it's mom? And then there's an expletive from Eric. And Craig, you're not checking it out still. I mean, it's Craig who brings it up. He's the one with the wire who's working for the police during this conversation. He basically interjects all the discussion about the homicide.
Well, the issue is what, if anything, your client responded to Mr. Cignarelli's statements.
What he's saying is, Cignarelli says, you're not checking it out still, and he says, I'm trying to.
All right, well, then that constitutes further evidence of the defendant's continuing to lie about the true circumstances or the circumstances of his parents' death.
And furthermore, number 17 is a discussion by Erik Menendez in which he suggests that Pittman Senpai Castro killed his parents because his father had intended to overthrow Castro. So this is just another story that Erik Menendez poses as to the killers.
All right, all of that is admissible evidence, as I've ruled,
Thank you.
as is 18.
19 we can await the further ruling as well as 20, 21, 22.
Well, let me just say, 21 Lyle's plans with money, I think
Okay, we're still not talking about that now, so we won't waste any more time on it.
23, 24. This has reference, 25 is out. 26, 27, 28,
And this is all.
29, 30,
I think 31 yards has to do with the witnesses' files.
31.
We would ask that we'll bring up 31. If he testifies in a way that makes that relevant.
Okay, at this point, we're talking about the people offering this evidence. All right. And in regards to the March 7,
And I agree with that. The statement given by Erik Menendez referred to guns rather than specifically shotguns, so I have no objection to that. With respect to your opinion, the court has already made a ruling on that. And with respect to burglary evidence, it has not been ruled on, so that will not be elicited. With respect to Friend 1, we're awaiting a ruling on the first 2 pages of the original screenplay. I'll go on to October 17th now.
yes,
With respect to the witness's fear for his safety, because he was a witness, I think that can be withheld unless the material becomes relevant later in the trial. As well as the number 2 under October 17th. Back to August 11th, again, the discussion of the original screenplay. Number 1 and number 2.
Number 2 is ruled on Friday.
Yes. The handwriting changes, handwritten changes to.
Okay, let's not talk about the screenplays. Let's go on.
I think he could, number 4, I believe that he can testify as to his familiarity with Erik Menendez's writing.
But for what purpose are you?
Okay, let's go on to something besides screenplay-related evidence.
Well, that really has, one aspect of it was the screenplay, but that isn't the only reason. There are certain documents that were looked at that I believe Craig Cignarelli can establish as Erik Menendez's writing. When he refused to submit to the writing sample, we have to have a known writing exemplar. So I think that he's able to.
Do you have the particular items that were shown to a handwriting expert?
Yes.
That you want to show him? Is that what you're saying?
Yes,
Your Honor, none of this is an issue. I've offered 6 times over to stipulate to his handwriting.
but
There's, and of all the people, they have a witness on the list supposedly just to bring out this document that the handwriting examiners, we're prepared to stipulate to his handwriting. So none of this evidence is necessary, and certainly not from this witness.
I think the relevance of the refusal to submit to a handwriting exemplar is that counsel in their opening statement seems to indicate that this was the defense, the self-defense, and their admission to doing the killing was something they always intended to do. When months after the defendant's arrested, he's still refusing to submit to a handwriting exemplar.
I think we're putting the
that
cart
is
before the
relevant.
horse. I'm not arguing whether or not the people should be able to prove that he didn't. All I'm saying is that now in this trial, for the purpose of giving this jury evidence, he's prepared to stipulate to the handwriting.
No, the people are trying to introduce evidence that he refused
Well, and you
to.
may allow them to do that. We haven't litigated that yet, but whether you do that or not, whose handwriting it is not an issue.
All right.
That's all I'm saying.
Well, if you're going to stipulate to the specific handwriting, the people still would be in a position of wanting to establish that regardless of your stipulation, they could have proved by other means that there was samples of your client's handwriting available.
Actually, he didn't, Your Honor, because their expert said that he could not come up with a conclusion.
So that's not the issue. The issue is whether or not at the time your client refused to submit to handwriting, he believed that the prosecution would be able to identify his handwriting as that which was on some critical documents if he had submitted that handwriting.
That may be, but my point with respect to this witness is that it is meaningless to bring out in this witness that he's familiar with my client's handwriting.
No, it's not. It, as I said, is evidence that puts before the jury information that even had your client refused to provide a handwriting sample, the prosecution had other means to do that and to prove it was his handwriting. So the fact that you're stipulating to it would indicate to the jury perhaps that, well, the defense has been cooperative all along and that this handwriting was always available and the defense was going to stipulate to the samples of the handwriting before the handwriting comparison was done. But that is not before this court. There's no evidence that that occurred.
Well,
And there's no evidence that you offered to stipulate to identify certain pieces of writings as your clients prior to the handwriting comparison being done.
well, there was a handwriting comparison being done, that was done, Your Honor, where they had conclusively claimed that it was not his handwriting before they ever asked him for an exemplar, and that was the reason why I advised him not to give them one.
Well, again, we're going beyond the
Okay,
issue
but,
here.
but the point is, I don't know, before the grand jury, when Mr. Cignarelli was being asked about handwriting, he was only being asked about the handwriting on the screenplay. So if the people are now saying they're gonna ask him about some other handwriting, I don't know what it is, but we just wanna make sure it's not the screenplay and the handwriting on the screenplay.
Right. Okay.
Well, just for the record, I dispute her reference to the handwriting being made to Erik Menendez prior to.
That really is nice.
All right, we're wasting a lot of time on this matter. If all you want to do is show some handwriting to the witness and see if you can identify it, you can do that. It's certainly not a major issue and it wouldn't be prejudicial in any way. So let's go on to something
With
else.
respect to number 6, Your Honor, I hesitate to agree to have that come out because in cross-examination, that may be relevant for this witness.
Well, it's
As to why he came forward. So they're objecting, but I do not want to preclude it from.
All right, if the issue of the witness's motivation to speak with the police and come forth with information becomes relevant, you certainly can go into his state of mind.
Thank you, Your
While
Honor.
we're doing this, can I approach and see if I can put these clips on the board?
Yes.
Number 7, I believe, also has relevance to the defendant's state of mind.
Your Honor, we had previously submitted in our 995 motion case authority indicating that a post-crime evidence of supposed lack of remorse is inadmissible, even in the penalty phase of the capital case. That's Triple versus Gonzalez, which is cited at page 65. The citation is 51 Cal 3rd 1179 at 1232.
And that court ruled that it would be inadmissible for any purpose under any circumstance or just under the limited circumstances presented to the court in that particular case.
Well, in Gonzalez, what the prosecution did is argue that, there was an argument that the prosecution's use of post-crime evidence of remorselessness did not fit within any aggravating sentencing factor and therefore shouldn't be used as aggravation penalty. And the court said that the prosecution there overstepped by suggesting that the defendant's claim of mistaken identity showed lack of remorse. The court noting that it was unfair to cite a proffered defense as proof of remorselessness. Now, this case dealt with the penalty phase, which obviously is a different type of proceeding than guilt phase, and I think the prosecution has to give significantly more latitude in introducing evidence in aggravation at a penalty phase. We are now in the guilt phase, and our position is that if this evidence of remorselessness or lack of remorse is not admissible in aggravation in a penalty phase, it certainly isn't admissible to prove guilt.
Well, the issue relates to the state of mind of the defendant, and my feeling is, based upon what has been presented by the defense in its opening statement and other remarks by counsel, is that the defense will try to get quite a bit of mileage out of the defendant's remorse in speaking with Dr. Rosiel and how upset he was and the nature of his emotionalism in that conversation. And if the people have evidence to conflict with that, then certainly it would be relevant on his true state of mind. And for that reason, it would be admissible. I don't know what it means to say that the witness described that he had no remorse.
I don't either.
It has to be a specific issue here, or specifically framed.
Right.
But you can't have it both ways. You can't say, well, the defendant was so upset about the whole circumstance, and then the next day showed that he was not upset at all, and his demeanor was quite the contrary, that he showed no remorse, not being upset or in any way distraught by the killing of his parents.
Your Honor, I agree with you. Our objection is to the form, is to this conclusionary language about lack of remorse. If they want Mr. Cignarelli to describe how he acted or how he behaved, that's different. But for them to simply, did he show any remorse? I mean, they asked us of every witness they ran into, the funeral director. Did he show any?
Okay, we're not talking about anybody but this, and I assume you have something more than just a conclusionary statement of Mr. Cignarelli, Mr. Kuriyama.
Yes, Your Honor.
All right, then, as far as if someone's not showing remorse, that is a conclusion and inadmissible as such.
I will not ask that question in number 8. Number 9, again, that has to do, that's 10 is out. This is 11. Is that just 6 maybe? Again, that may become right by the class. Well, Your Honor, with respect to the final objection, if the defense intends to bring out that incident, I believe that I should be able to get a clarification from Mr. Cignarelli as to why the incident occurred, according to Mr. Erik Menendez. So if they don't intend to present that, then I would have no reason to.
Well, we would like to present it, whether we're going to do it now or later, I'm not sure, but we would like to present it as a showing, as a demonstration having nothing to do with Mr. Cignarelli, but having to do with Mr. Menendez's volatility and potential for violence.
Well, that incident relates to Mr. Menendez threatening to kill Cignarelli at a time when Cignarelli was at the Menendez house,
Yes.
and Erik Menendez telling Craig Cignarelli the reason Mr. Menendez did that was because of Mr. Menendez's anger regarding Cignarelli's involvement with Erik Menendez in the burglaries. So if you go into part of that, then the rest of it will no doubt come out.
Well, let me just
You
indicate.
can't have it just limited to what Mr. Menendez did without reference to why he did it.
Well, I don't know that why he did it is particularly relevant. Moreover, what Mr. Cignarelli said, he had no idea why this happened and never discussed it with Erik again until after the parents were killed. So it's like a year later.
Still, if that is the information Erik Menendez related to Mr. Cignarelli, then it would be admissible.
Right, then we will wait for a ruling on the admissibility of the burglary evidence and perhaps have the witness back depending on the court ruling.
All right, as I said, since the information regarding the burglaries has just been submitted at the outset, the first day of opening statements by objection by the defense, and then has been submitted by the prosecution today in its voluminous filings that the court has yet to read. The matter will have to wait until further hearing. All right, anything else now other than the screenplay in regards to, and the perfect crime evidence in regards to the testimony of Mr. Cignarelli?
No, no.
All right, regarding the screenplays, the first screenplay, the court has again reviewed that material and using an analysis under section 352 of the evidence code, dealing with whether it has any probative value and comparing it to the prejudicial effect of introducing the evidence and its potential to consume an undue amount of time and create a substantial danger of confusing issues and misleading the jury. The court has balanced these factors, and I find that the fact that the screenplay was co-written by someone else, it was written well over a year before the incident, that the testimony of Cignarelli indicates that it was a joint product, one that was shared with the intended victims in this case, or the ultimate victims in this case, as well as Mr. Cignarelli's mother. All of this indicates to me that the probative value of this evidence is nil, and the potential for undue consumption of time and potential to confuse the issues and mislead the jury is great. Therefore, the court will sustain the defense objection to the admissibility of the first screenplay as well. I don't find it has any probative value, and whatever probative value it has is substantially outweighed by the negative factors that I have indicated here. In regards to the perfect crime evidence, did the prosecution intend to introduce that during Mr. Cignarelli's testimony?
Yes.
And what is the purpose of that?
The purpose is to show the defendant's preoccupation with committing a perfect crime, that in the statement to Dr. Ozio, he reflects that we had done the perfect crime. First of all, he thought the burglaries that he had done earlier in Calabasas were perfect crimes, but that his father criticized him for those, and that later he felt, according to Dr. Oziel, that he had done the murders perfectly. It shows a preoccupation, an interest by Erik Menendez in doing a crime and being able to get away with the crime.
Well, are you offering this as evidence that Mr. Menendez was planning to commit other crimes that he would describe as perfect crimes?
I'm presenting that evidence to show that he had contemplated doing other crimes or trying to do crimes perfectly. He had that overriding interest in being successful in doing these crimes, and discussed it at length with Mr. Cignarelli.
And what specific crimes was it or that they were contemplating?
They discussed, I believe, Mr. Cignarelli said the perfect burglary, robbery, and even murder.
And did they go into details as to how these things would occur?
Well, that I suppose has to do with the screenplay evidence, which the court has excluded. But
Other than the
that
screenplay?
was part and parcel to that discussion of doing perfect crimes.
All right, it seems to me that this might very well be related to Oziel's testimony as well as the burglary evidence, and it can be held in abeyance until that time. We have hearings on those issues, and it could very well be that that would come out. The court is not foreclosing it, but would order that you not go into it during this stage of Mr. Cignarelli's testimony, with the understanding that Cignarelli may well be required to testify later in the trial.
Very well. With respect to these issues, these objections, may I have a few moments with Mr. Cignarelli so that I can tell him not
All right.
to go over these areas?
Yes. All right. We'll take 10 minutes and give you a chance to speak with him.
Thank you.
And if you need more time, let me know.
Okay.